Good evening, my dear friends. I am Deepanshu Sarkar, and I am here today to present a topic on insolvency and bankruptcy. Basically, insolvency and bankruptcy and its legal journey, the new code, the Insolvency and Bankruptcy Code 2016, which was enacted on 11th May when the presidential assent was given. So I would like to talk about that, and I would like to throw some light upon the flow of discussion which I would be telling. So I would like to start. What is insolvency and bankruptcy? Insolvency and bankruptcy means when a person or an entity, like a legal entity, a company, a partnership firm, an individual or a proprietorship, fails to meet its cash or financial obligations towards its creditors or lenders. That is, the entity is the borrower of some money and the creditor is the lender of the money. So when an entity cannot meet its financial obligations, it becomes bankrupt. So why does a company declare bankruptcy? In a company there are workmen, there are creditors. So there are so many people who are actually working towards the development of the company. And when a company becomes insolvent, it actually becomes difficult to pay the workmen, the employees, their salaries, and the creditors, they cannot get back their money. So that is why there has to be a tribunal or a institution where these insolvency and bankruptcy related issues has to be solved. So it's very necessary to file an insolvency petition. Okay, now I would like to discuss the people, the creditors, who like the employees, the workmen are the most important and the priority holders in a creditor, because they put their blood and sweat for the company to develop and reach its heights. And the second is the secured creditors, that is the banks and the non-financial institutions, so who are lending their money so that the company develops. And the third are the unsecured creditors, like the shareholders of the company, who buy the shares of the company so that the company can develop. Okay, so what does an entity do when it becomes bankrupt? In the previous laws, there was a National Company Law Tribunal set, NCLT, according to the Companies Law, Companies Act 2013, where all these company related proceedings shall be held. There is no civil court regarding to this. NCLT is formed, which is mandated by the section 408 of the Companies Act. Okay, now the previous laws and the new law governing bankruptcy: the Companies Act 1956, Sick Companies Act 1985, the Recovery of Debts 1993 Act, the Sarfaizi Act, the Companies Act 2013. The reason behind mentioning Companies Act 1956 and 2013 separately is that the Companies Act 1956 in Part 6A and Part 7 and Section 391 mentions 1956, and in the 2013 Act, the Chapter 19 and Chapter 20 separately mention insolvency. And now comes our new code, the Insolvency and Bankruptcy Code. It is actually a consolidation of all the bankruptcy related laws in one box. That is what it is, like all the same product in a new packaging. So this is our Insolvency and Bankruptcy Code. I would like to talk something about this Insolvency and Bankruptcy Code. Why was the law enacted? Actually, our company is going through a phase where $150 million of bad debts are actually overhanging above us, and the recovery rate by the lenders is just 20%, which is one of the worst recovery rates of the world. So, and our country is a booming country of the young entrepreneurs who have to form their new entrepreneurship. So some reforms are actually needed for the entrepreneur dynamism to improve in our country. That is why Insolvency and Bankruptcy Code was formed. Like it's mentioned here, this is the previous laws did not have a proper negotiation between the creditors and the debtors. The previous laws are so redundant. They did not have a proper mentioning of insolvency and bankruptcy. So the people, what they used to do, they used to make an out of court settlements, so which were not very effective, and the workmen, the companies, they were shut down, and the workmen did not get their equal pays and wages and remuneration, and the secured creditors also could not get their loans back. So and this code actually forms a process in which proper negotiation and the supervision would be done by a resolution professional who would be supervising all the insolvency proceedings. Okay, now I would like to explain how this process actually happens. The Insolvency and Bankruptcy Code actually revolves around this ecosystem. This is the Insolvency and Bankruptcy Board of India. It is an apex body which actually looks at the transparency of the proceedings, so that there is no cheating involved in the proceedings. The Insolvency Professional Agency, this agency is finds a place in section 201 of the Insolvency and Bankruptcy Code 2016. This agency is used to recruit the insolvency professionals. The insolvency professionals are the people who, when a petition is filed in a company, the powers of the board of directors are completely vested in the insolvency professional. This person finds a place in section 207 of IBC 2016. And information utility. This is a repository in which all the information of the creditors, the debtors, the borrowers, every information about the corporate firm is mentioned in information utility, section 210 of Insolvency and Bankruptcy Code. Okay, then this is the committee of creditors. The creditor committee, it is a committee formed when there is an insolvency petition filed. So what they do is they actually decide how to evolve the company from insolvency or the further proceedings, which I will be talking in the subsequent presentation. The NCLT, the adjudicating authority, this is the authority which actually accepts the petition of insolvency or rejects the petition, or it rejects the resolution plan or helps in implementing the resolution plan which is being formed for the company when it is insolvent. Okay, now I would like to explain the corporate insolvency resolution process, CIRP. So what happens is, when a company applies for default or a debt to the adjudicating authority, that is AA, what they do is they appoint an interim resolution professional or the IP, and this IP conducts a meeting with the committee of the creditors within the first 7 days, and the committee of the creditors actually determines whether this insolvency professional would be fine for our company or not. So if it's fine, then he will move forward, and then the resolution plan would be implemented. And the date from which the company applies for the default and the insolvency professional is recruited or appointed for that company, that date is known as insolvency commencement date, and from that date all the powers of the board of directors of the company is vested in the insolvency professional. He and the board of directors will not function. They are just a party in the committee of the creditors. They can sit and vote. And this is the moratorium period. What the moratorium period is actually 180 days, that is approximately 6 months. This is a very important factor which has been actually made by the IBC, that is all the company insolvency related proceedings will be solved within 6 months. In the previous laws there was no such special date, and the proceedings were means they were running and all, and there was no solution. So that's what the new code has been proposed. And within this period the committee of the creditors forms, and the 75% of the creditors, if they approve of the resolution plan which is being formed by the committee of creditors and the insolvency professional, then the implementation of the resolution plan would take place. Otherwise the company would go into liquidation. So what happens in liquidation is, if the resolution plan is implemented, it is finished within 180 days, all the proceedings, and If it evolves, it's fine. If it does not evolve or the resolution plan is not passed, then the company will go into liquidation. In liquidation, what happens is a very great thing which has been mentioned in the IBC is there is a proper order of priority. When the company goes into liquidation, how the distribution of assets would take place. So that is mentioned in section 53 of the Insolvency and Bankruptcy Code. And in a very important thing is that earlier the secured creditors and workmen were kept in a, I would like to explain this like with a Latin maxim also known as pari passu, which is that equal footing of secured creditors and the workmen. But now what has happened is, since the workman has put his most energy in making his growth and the company's growth, the workman dues are the topmost priority now, and then is the secured creditor. So this is a very great thing. And now I would like to explain some key takeaways, that is the key highlights of IBC. It is actually a paradigm shift, which in the previous position it was all the rights were given to the debtor. So now it is a shift from debtor in position to the creditor in control. Now the creditor has the control whether to implement all the insolvency proceedings, and everything now is in the creditor's hands. And now the creditors are actually more protected. They feel more safe that their money will not go waste, and finally they will get back their money. And as I mentioned that it is a strict time frame of 180 days, and in the rarest of the rarest cases it extends by 90 days, that is 270 days is the maximum limit within which they have to finish the insolvency proceedings at any cost. And also I mentioned that it is a consolidation of all the pre-existing laws. And according to section 238 of Insolvency and Bankruptcy Code, it has an overriding effect on all the previous laws. So I would like to conclude by saying that IBC is it has been enforced in 2016. So we hope that it is a good and good code in solving the bankruptcy process. Thank you. In the subsequent videos, we will be talking about voluntary liquidation and insolvency proceedings for individuals.